It's time now for KMTS Connections, a public affairs program from KMTS News, heard weekdays around 12:30, bringing you interviews and information regarding nonprofit events and city and county services from Aspen to Rifle. KMTS Connections connect you to everything that matters in the Roaring Fork Valley and beyond. Once again, it's Gabe from the KMTS Morning Show, talking about DUIs and the law involving DUIs and some of the more intricate details of how we deal with all these DUI cases. And, of course, we've all heard the tagline, "The heat is on," over the last several years. Joining us today is 9th Judicial District Attorney Sherry Caloia. She's got a law degree in criminal justice, a law degree and a criminal justice degree. She's also been a partner in several local law firms, focusing on water law, among other public and private areas of law. She's a former assistant district attorney in the Denver area, as well as assistant county attorney in a couple different places, 3 different capacities in various locations in Colorado. Also, a guy whose voice you've heard many times here on KMTS over the last 20 years or so, Dan Shipp, Master Trial Advocate by the National Institute for Trial Advocacy, Notre Dame Law School, member National College of DUI Defense, and a lecturer at the Colorado Criminal Defense Bar, or for the Colorado Criminal Defense Bar, I should say. And finally, Robin Starr is a Colorado addiction counselor and owner of Addictive Behaviors Counseling, currently still working on PhD.
Yes, endlessly.
And she teaches Level 1 and Level 2 DUI education classes, which are mandated by many courts. The courts in our area are no different. And also on the board of a local organization called CenterWorks. They offer support to people who are in recovery. Recovery is a word that a lot of people probably don't attach to DUIs. It's interesting looking at the history of DUIs. There's always been, going back to the early 20th century, laws on the books. Depending on which history you look at, I found a newspaper article from, I think it was a Detroit newspaper, talked about the very first liquor law was actually established in Massachusetts. And that was in 1907, something along those lines. And the article was very supportive of some kind of drunk driving law. Very clear. I think we can all agree that we don't want people who are drunk getting behind the wheel. Around the early 80s, there became a movement, thanks in part to an organization we now know as Mothers Against Drunk Driving, which was started by a lady named Candy Leitner. And her 13-year-old daughter, we've all heard this story, was killed by a drunk driver. And she decided she felt it was very important to do something about it so that other parents would not have to go through that same thing. However, a few years later, in 1985, she actually began disassociating herself from Mothers Against Drunk Driving. That might come up as we go throughout the conversation here. It's a very complicated thing, as you can imagine. Anything dealing with law and courts is not something that you can just put into one paragraph form and be done with it. But we'll try and delve into all the aspects of it and try and figure out how these 3 people who are here today reconcile all of this at the end of each one of these court cases. I should mention, by the way, we tried to get a district court judge to come and be here with us today, but they just couldn't figure out scheduling and that kind of thing. Although I was really looking forward to that because I figured a judge, a district attorney, and a defense attorney, there's no reason for me to be here. It'll be just like another day in court. Right. So first of all, driving under the influence laws, let's keep this to Colorado because otherwise things will get way confusing and convoluted. Colorado for years, probably around 30 years, when the MAD organization began really pushing states and at the federal level for tougher DUI laws, Colorado had thresholds of 0.1 for the actual driving under the influence, and driving while ability impaired threshold was 0.08? Was it 0.05? 0.05, yeah. And so last year, a big movement, I believe also spearheaded by MAD and other organizations, other advocacy organizations, to lower that DUI limit to .08. And Colorado was one of most of the states in the country that decided to go ahead and lower that threshold. I think there may have been some kind of inference about losing federal highway dollars and that kind of thing.
I think that actually happened in 2004.
Yeah, it's been that
So
way
it's been a while, yeah.
And it is tied to federal dollars. There is a federal law that restricts federal dollars for highways if you do not have a level of .08 for your DUI.
So it's either do this or you're going to lose some of those fun. And
It was going to cost us $50 million if we didn't drop it down.
And anybody that drives roads in Colorado knows that we need every dollar we can to try and fix them in the summer from all of that maintenance that we have to do in the winter. Something interesting to me, it's the National Highway Transportation Safety Administration that comes up with a lot of the figures that we're familiar with as they pertain to DUI. They consider a fatal crash, so a crash in which someone dies, as being alcohol-related if a driver, a non-motorist like a pedestrian or a cyclist of some kind, or a passenger has a blood alcohol content of .01 or greater. Keep in again, .05 is the threshold for driving while ability impaired. So .01 or greater, if anyone in the vehicle has a blood alcohol content higher than that, the NHTSA considers that crash to be alcohol-related. That's interesting to me. The first part of it is I wonder why they consider even a passenger. Do they consider that to be a distraction to the driver? Anybody have any comments on that?
The problem I've got with that is that when you look at what is generally presumed to be the threshold at which there is a alcohol-related accident or fatality, most people assume that you're going to be in violation of the law. Basically what's done here with the National Highway Traffic Safety Administration, they've wanted to make some sort of determination or threshold issue with respect to the alcohol, and it does give us an idea. If you've got somebody that's a .01, they could be messing with somebody that's driving. I don't know. That's their threshold. That's what the figures that we look at when we see that there are 30,000 people arrested in Colorado each year for some sort of alcohol-related offense. That's not what they're talking about. Generally, when they talk about an alcohol-related arrest, they're talking about the .05 or higher.
Sure.
So. Right, and it's interesting because when I was looking up the number of fatalities that in which alcohol is involved, I mean, you can find numbers between 10,000 a year and 17 or 18,000 a year.
And it looked to me like the numbers are going up over the last couple of years.
The numbers have not been declining, I will say that.
The death numbers have not been declining. What has been declining generally are the arrest or the people. And if you go back to 1982, you saw a lot more fatalities back at that period of time than you did last year. And they've been basically declining from around the neighborhood of 700 to 800 fatalities in 1982 until now.
So you're saying it's not necessarily a trend. It's we've reached an average, if you will, and so it's waves up and down.
There's other reasons for fatalities, not just alcohol. If a person's wearing a seatbelt, a fatality could be avoided. We have safer cars now, so there's a lot of factors that go into this. Safer highways,
divided
true.
highways.
Mm-hmm.
This is true. And you mentioned that there's a presumption that someone, if they're drunk, they're going to be violating the law. Actually, and I don't know exactly what the threshold would be or what would trigger this, but you can actually be arrested if your blood alcohol content is above a certain threshold, whether you're driving, operating a motor vehicle or anything else or not in Colorado under certain circumstances, can't you?
You can be asleep in the car.
Well, are you talking about arrested for DUI or arrested for other offenses?
I'm saying arrested for other offenses.
Okay. There are some municipalities that do have laws concerning open containers, being in the wrong place, that sort of thing. Just being drunk and walking home on a sidewalk, I don't think is an offense in most places.
So it's more, and this is not a legal term, this is a lay term, more of an aggravating circumstance as opposed to the actual reason why you would be arrested.
If there
If
was
that makes
another
sense. Right. In other
crime
words,
there.
if you commit a crime and you happen to be drunk, then there might be an additional charge because of the alcohol, is what I'm... Okay.
There might be other reasons, but
Okay.
just being drunk is not really an offense.
A party that might be a candidate for an arrest might be someone who's drunk and disorderly. I see that come through my agency often. So the disorderly conduct, even if you've only had one beer, can initiate some police contact. So it really depends on the behavior.
Could that also have something to do with the mental illness of the person being contacted?
Certainly.
And that certainly speaks to the very nature of alcohol. It is a neurological depressant, and so it can accentuate if you have certain problems, if you have certain... you tend towards certain types
Acting
of
out.
personalities. Yeah, exactly.
It can eliminate your inhibitions.
Exactly.
Sure. Let's talk about what happens when someone is arrested for DUI. There are actually two different angles to what happens in a DUI case. The first thing that happens, and maybe very quickly, depending on the circumstances surrounding the arrest, is the Department of Revenue, which licenses us to drive in the state of Colorado. There's a DOR hearing, and typically there's a loss or revocation of the driving privilege. Am I getting it more or less correct there?
That's generally correct. Basically what happens is Colorado has a law called the Express Consent Law. Basically, by the act of driving in the state of Colorado, if an officer has a reasonable suspicion to believe that you're driving under the influence of alcohol or drugs, he can request a test of your breath or blood or urine to make a determination if you are actually under the influence. If you refuse to take that test, you will lose your driver's license for 1 year. Now, the state legislature has just made some changes on that because of some problems that were being created by it. But with respect to what you say about the Division of Motor Vehicles, yes, you do have a hearing, but you have to request that hearing.
Right. So in the field, if you get arrested for DUI, you refuse to take either a breath or a blood test, the officer should and is required to take your license at that point from you. They will issue you a pink slip, which gives you the right to drive temporarily. I believe it's 7 or 10 days.
7.
You have to request a hearing with DOR within that period. It's a very short period. And then go to a DOR hearing, which would be held usually within 2 months, to determine whether there was actually probable cause to arrest and whether you were correctly offered the test and refused. At that point, you might then lose your license for a year.
It seems to me like in most cases it really is a matter of, it's academic.
7,600 people out of the 30,000 people that get arrested each year refuse tests and lose their license as a result, whether they're intoxicated or not.
And that would be really the takeaway from this for people that are listening. Mm-hmm. If you refuse the test, you lose your license.
Absolutely, whether you're intoxicated or not.
You also lose your best defense that you weren't drunk. Mm-hmm. Quite frankly, just yesterday we had a jury trial with a guy who refused to take the test. And the best argument to the jury is, he didn't take the test. Why wouldn't you take the test? To exonerate yourself. Well, the reason is because you're probably intoxicated.
Well, I come on the other side of that argument. With respect to that, probably you're intoxicated, but there is a presumption of innocence that goes with you, and you don't have to prove your innocence in these things. District attorney's got to prove you're drunk, and what they're going to do is they're going to use other observations. There are certain tests that the officers tend to give you that may give you some indication of intoxication, or just the fact that you're falling down on the ground throwing up and you didn't take the test might be the fact that you're intoxicated. But you might be sick, or you might be an epileptic, or you might have a diabetic condition. So there are other things.
I think part of the confusion in all of this is the roadside tests are not mandatory. You do not have to take those. However, if the officer says, just talking to you here, I'm smelling alcohol, I'm noticing your eyes are kind of watery, you were driving into the oncoming lane of traffic, I'd really like to do, you have a choice of a breath or a blood test. I'm going to make that decision to arrest you and give you those tests. If you refuse that test, it's all over.
Well, not necessarily.
Well, okay.
The roadside tests are a search under the Fourth Amendment. You don't have to participate in those unless there's a search warrant issued. What ends up happening is a lot of people will want to do it to be able to convince the officer that they're not intoxicated. One of the big problems that I see is about 20% of our law enforcement has an overzealous nature with respect to prosecuting DUIs. About 80% are absolutely wonderful. But what ends up happening with you, if you have an officer out there that's being overzealous without seeing the watery bloodshot eyes, or without seeing the lack of balance, he may well infer that you are intoxicated and arrest you even without those roadside tests.
And that's why you want to take that blood or breath test, because that's your best evidence to show the officer, hey, I wasn't drinking, or I was below the limit. Now, I disagree with that figure of 20%. The officers that we see are right on with their evaluations of people who have been drinking. Now, remember, we're not talking about drunk driving. We're talking about driving after you've been drinking and are impaired. Driving is a dangerous activity. I think everybody would agree. You've got a 2,000-plus pound piece of steel going at 60 miles an hour. That's a dangerous instrument. You need to be fully aware of all the circumstances in order to be safe, in order to avoid a crash, which might be somebody else's fault. That's what we want on our highways.
It's interesting you bring that up, too. In my research, I was looking at the historical laws for what we now call DUI. And initially, it was the laws were written to determine whether you were drunk or not. They were much higher, around, I think, 0.15 was a common previous threshold.
Correct.
For DUI, for driving under the influence. And again, they were designed so that if you were drunk, you should not drive. And again, over the last 30 years or so, there's been this larger movement to, okay, maybe you're not drunk, but are you impaired?
Actually, we have a statistic from the Colorado Department of Highway that this was given to us probably 10 years ago, that if you've consumed one beer, traveling 60 miles an hour, it takes 35 more feet to stop the car than it does if you have no alcohol in your system. So one beer can affect or slow down the response for a human being to make a decision, to see what is needed to be done, and to then actually program their body to do whatever it takes. This is an interesting little tidbit because it really implies that any alcohol can affect you, just enough that it might make a difference between being alive or dead.
And that certainly would be the position of the National Highway Transportation Safety Administration.
And I disagree with that concept, because not everybody is going to assimilate that one beer like everybody else. I would be willing to challenge Robin Starr to tell me that not all drugged driving is bad. And with respect to that, what I would say is that if I take Dexedrine with a normal attitude, it's going to make me hyper and going to make me breathe heavy. It's going to make my cuticles dilate, and it's also it's going to make me more excessively perspire.
Forgive my ignorance. Dexedrine is a stimulant?
Yes.
Okay.
Okay, but if you give Dexedrine to somebody that's got ADHD, it actually settles them down, so it may make them a more conscientious driver as they settle down and can pay closer attention. So what I'm saying is 1 beer for everybody in the population. I disagree with that concept.
I didn't say that it impaired each and every person. It does affect them. Some people take medications like stimulants because it helps them to be normal. And so it would improve their driving theoretically, would it not?
That was my theory.
Well, that's still a good theory, Dan.
Okay.
And it really depends on how big the person is. You might
True.
have a big guy who has 1 beer. He might be below the 0.05. In fact, he probably will be. However, if I drank 1 beer, I'd probably be over the 0.05. And I'd also probably be a little impaired.
And I would probably be napping in the back seat.
But it can also depend on what you've had to eat. If you go out and have pizza and you've got a coating of cheese oil on your stomach, it's going to slow your absorption of alcohol.
And tolerance, and that's kind of what Sherry and I think, are talking about too. Tolerance plays into, particularly alcohol, to a great degree, doesn't it?
Absolutely.
You know, the theory behind the curriculum that we teach, mandated by the state of Colorado, is that each beer, 6-ounce glass of wine, or 1 ounce of hard liquor intoxicates a person at 0.015 per drink. So you would have to have at least 3 drinks to be over the limit, theoretically. But again, it's also coupled with your weight, your metabolism, etc. We do teach this in DUI Ed, that if you're going to try to have a cocktail and then drink, you have to know your limit. And no one knows that exactly. They can't just know that from statistics provided by the state, because all of these other conditions and variables factor in.
So your best bet is just don't get
drink
out there
and
in the
drive.
car.
Right.
What I might
Having said that,
what I might suggest is, if you go to the Colorado CDOT website, you will find there a BAC calculator.
Correct.
And it works with the a man or a woman and your weight, and it determines whether, when you started drinking, how much you had to drink, and what type of alcohol you had, whether it's beer, wine, or liquor. Now, I strongly suggest, as will Robin, I'm sure, that if you have 1 drink and you weigh 112 pounds and you have a glass of wine, you better darn well know where you are, because you, and you can learn that from that app. I've got one on my phone. It's wonderful.
having said that, it's not foolproof. There are other factors that are, it's, we're not advocating you go get the app, and well, the app said I was okay. You owe me $10,000 for my DUI defense and all the
Right.
classes and all, restitution.
Wait a minute. You don't imply that I charge $10,000. Hold on.
He's not that cheap, believe me.
One of the things that has become more and more popular over the last 10 years or so is marijuana. It was legal as a medical substance, as a treatment for certain things. And now, with the passing of Amendment 64 in 2012, was now, as of January 1st this year, legal for any adult over the age of 21. There are still a lot of misconceptions about recreational use of marijuana in Colorado. Probably the biggest misconception is you can't do it in public. And I'm not sure locally how many folks have been arrested for smoking marijuana in public. But really, in the context of this conversation, the question is, how many people are getting behind the wheel after consuming marijuana in some form or another? And having said that, while recreational marijuana is a new thing in Colorado, the impairment laws really are not new. They've been on the books forever. I mean, we think of DUI as driving under the influence of alcohol, but driving under the influence of some kind of drug, be it prescription or illicit, has been on the books forever. That's not a legal term, that's a lay term.
Right, and we are seeing a number of DUIDs, we call them, driving under the influence of drugs, specifically marijuana. The officers are getting trained as DREs, drug recognition experts, to be able to do the test to determine whether someone is under the influence of marijuana or other drugs. It's different. Your body acts differently than it does when you are on alcohol. What you have to remember is marijuana is illegal, and that's fine, but don't go out and drive right after you've smoked.
Dan, I agree with that.
You actually have some specific information about marijuana and how it's metabolized.
Absolutely.
First of all, there's no tolerance to marijuana, right?
No, you don't build up a tolerance like you do with alcohol.
So there is a level, 5 nanograms of active THC in your bloodstream is a, I think they call it a permissible inference that you are under the influence. And you can only get that through a blood test. You are offered a blood test. You don't have the option to choose a breath test for marijuana. And if you are over that limit, we will go forward with that case.
If you take one hit off a marijuana cigarette and just a small, one quick hit, you're going to go to at least 15 nanograms. It's coming. And if you get a bong hit, and it can be a big bong hit, you can go into the hundreds of nanograms, and it'll stay with you for an hour and a half or more. So you've got to be real careful in the automobile. Do not drive when you're smoking pot. Well, another thing is the cop's going to smell it when he opens the door of the car, and that's going to be a sure sign he's going to ask you out. You just don't need to get in that position.
And, contrary to what a lot of people say, that will dissipate from your system after a period of time. So you should not test positive for active THC in your bloodstream the following day, for example.
Generally speaking, if you go up to that hundreds of nanograms limit or amount with the ingestion of, say you smoke the whole cigarette, what ends up happening is your BAC, or your, not BAC, but your nanogram level will go up very, very quickly, but it will also come down very quickly. But it might take an hour and a half, 2 hours for it to get down to the 5 nanogram level, but then it would level out, and it might take 2 hours before that active nanogram level leaves your system.
Wait till you get home to smoke your marijuana.
Or eat it or whatever.
Or eat it. Just wait till you get home.
Don't eat it at all, because you don't have any concept where you're going with that high. The way to cook marijuana has not been quantified to the state that people can tell you how many nanograms you're going to be getting with any given amount.
So, I think that's maybe the most important part of this whole conversation to me today. Dan, as someone who represents hundreds of people every year, be it DUI, alcohol, drugs, whatever, you're very clearly saying it's not worth it.
Don't eat it at all, period.
Yeah, it's not worth it to go out there and drive. After you've smoked, after you've drunk, it's not going to be worth it.
We're seeing a lot of information coming in now. There was a kid that jumped off a 4-story roof with marijuana in his system, and apparently that was the reason for it, because he overdosed on marijuana. We just don't know where this edibles is going.
And I guess it's probably one of those things there might be more research on as time goes by, but it's just so new.
Yeah.
Well, it was illegal for so long that doing research is difficult. Sure. Now that it's legal, I think we're going to see a lot of that research.
We had some of it in Mississippi. We had the only legal grow facility at the University of Mississippi in 1971. So.
Well, there was a federal medical marijuana program in the 70s, wasn't there?
At the University of Mississippi.
Really? I did not know that.
Absolutely.
I learned something new today that I didn't. Well, actually, not just one thing. So the question is, we learned about the laws. Again, obviously, getting behind the wheel if you're impaired in any way is not a good idea. I mean, I remember driver's ed. They told us, even if you feel sleepy, pull off, sleep for a few minutes, get your legs back underneath you. And it's the same thing with drugs or alcohol. Clearly driving is not a good thing if you Go ahead.
You just gave us a misconception. You were saying if you're sleepy, pull off. You can't do that if you're drunk or high on marijuana. You can't pull off and go to sleep.
I'm saying don't do it in the first place.
Okay, I got you.
Yeah, sorry about that. I should have been more clear. The question is, where do we go after the DUI conviction or the DUI court case? Whether there's a conviction or not, there are going to be some effects from just being arrested and going to court. I mean, at the very least, you're going to be inconvenienced. And Robin, you're actually an advocate of something that's called adult treatment court.
Correct. We have a program in Pitkin County we've been doing since 2007 that is likened to the drug court program, national drug court programs that are happening now that are typically for felons. This court is a hybrid, and it is geared specifically for people that have had multiple DUIs. The overview in layman's terms is if you've had one DUI, you may have made a bad choice. It might have been a problem with thinking. If you have 2 DUIs, then we look at whether you have a problem with thinking and drinking. If you have 3 DUIs, then we're really looking at there may be a real problem with drinking here that needs to be addressed. Obviously, you can't punish what the American Medical Association terms a disease. Alcoholism is a disease, a condition, whatever you want to term it. It's clearly something that has to be treated, and you can't punish it out of someone. I am not advocating for no accountability with regard to breaking the law. However, it isn't going to help us to be safe in our communities to merely punish people who are getting multiple DUIs. So we have designed and developed this particular treatment approach with the DUI drug court program, which allows people to stay out of jail. They may do a small part of their sentence in jail, depending on the mandatory law, how many days they are required to do, but the remainder of their jail sentence is suspended per completion of this program. The program is typically 12 to 18 months long. People come to group just like they would if they had any other DUI. They learn the curriculum about drinking and their thinking and their beliefs that propel certain choices, both bad and good. Those behavior choices we look at specifically in the treatment court, and we have an approach which is called contingency management. Contingency management is used in any environment, in employment, in training. It is merely a conditioning of behavior. So there would be sanctions and incentives. Sanctions obviously will be imposed for negative behavior, such as tendering a hot UA, showing that you've been consuming alcohol and or drugs. And a incentive would be possibly a less drug testing. Your drug testing requirements would be lessened. The period of time that you get to have elapsed between court reviews might be lengthened. That would be an incentive. These are in place to reinforce on-task behavior while receiving therapy. People drink for lots of different reasons. And normal people, healthy people drink. We have a community, a culture where we absolutely we advertise and promote drinking for almost any activity, for a wedding, for a funeral, for graduation, for a celebration, for engagement. It is part of our culture. However, people sometimes forget or just haven't learned that there are many other ways that they can celebrate, that they can enjoy themselves. And because we live in a resort valley here, this is party central. This is where you'll come to play on vacation. So the people that live here oftentimes get caught up in that party mentality.
Well, and with recreational marijuana, it's where people from all over the country come as well to recreate because of the recreational marijuana industry.
Well,
Absolutely.
we don't want people to come here on vacation and leave on probation.
That makes sense. But, Sherry, what she said does make sense. You cannot punish a disease. And yet, I believe it was during the break, we were kind of visiting just the four of us, and you said you believe that the system as it is right now does work.
I believe that it does. The vast majority of people who get arrested for DUI learn their lesson and they don't come back to court. In that regard, I think the system works. A lot of people who get a second DUI learn their lesson after the second DUI and don't come back to court. For those people who do it repeatedly, the punishment is for the driving, not for the drinking. But we really need to change that person's behavior. And getting quick consequences to these violations, I think, is a very good program to get them to change their behavior. So instead of the traditional, you got a hot UA, guess what, your probation's revoked, you're going to jail, you're going to prison, you acknowledge that these people who have a drinking problem and that's been ingrained in them for a long period of time, they're probably not going to succeed the first time, the second time, the third time. They're probably going to screw up, go out there and drink. But if they do, you recognize you screwed up, you went out and drank, we're going to give you a consequence for that. Maybe it's a day or two in jail, maybe it's something else, and then you get out, let's try it again. And those courts have been successful all over the country. I love that approach because it recognizes that we are all human.
It works.
It does work.
It works.
We have incredible statistics, amazing statistics. Across the state, I believe the average is 67% success rate for reduced recidivism and relapse. In our court in Pitkin County, we have a little higher success rate there. We do see these people in court where they come in for reviews typically about every 2 weeks. So they stand or sit in front of the judge. I'm present with them, and the probation officer is also present.
So there's continual supervision.
All the time.
And support, I guess, would be a better way of putting it.
It is supportive, and the drug court is a team. So we are all on the same team, including the client. The client gets a chance to speak, and if they've had some type of infraction, then they will receive a sanction. The sanctions are very, very temporary. We are only trying to reinforce positive behavior. We're not pulling the party out of the community to incarcerate them to make the community safe. We already have ways of making them safe. They have no driver's license. If they do have a driver's license, they have an interlock. So having a drink doesn't mean that you drank and drove. It means that you had a relapse. So unless there's criminal conduct, we don't need to put that person in jail. We need to up their treatment. We need to find some ways to motivate change and spend some time examining their cognitions, how they think, how they feel about an event, what they believe about it, and what behavior is born from those beliefs and those feelings. Sometimes they're very inaccurate for many of us. We don't always explore our own thoughts and feelings and beliefs. And we have some beliefs that may be archaic, they may be inaccurate. It happens in the best of us. So this is what we try to approach in drug court. It's been incredibly successful.
We talked about alcohol, we talked about marijuana, and those are just two of the drugs that can impair driving. There are other prescription drugs that have been around forever. I think the big one right now is Ambien. You've seen a lot of Ambien cases, Sherry.
We have seen Ambien cases, several Ambien cases. I don't want to say a lot. And people might be familiar with a New York case involving one of the Kennedys who stated that she took Ambien because she picked up the wrong bottle. That does and can happen to people. Be careful. Make sure you're not doing that because going out and driving on Ambien is very dangerous. You are definitely impaired. There are sleep driving cases where people have gone out and gotten into the car when they're sleep-induced under Ambien.
Well, that's one of the side effects, isn't it, as sleepwalking?
Sleepwalking is one of the side effects. So if you're taking Ambien, maybe you should take some extra careful efforts to make sure that you're not in a position where you're going to go out and do something. Go to bed. If you take the Ambien, go to bed. Don't put yourself in a position where you're going to do the sleepwalking.
And Ambien, at least the full-strength Ambien, is, did you tell me this?
Well, many
before,
sedatives
Robin?
have half-lives. I believe that the Ambien has half-life of up to 28 hours.
28
Valium has a half-life of 28 hours. So mixed with alcohol, even if you've had some hours between your dosage, if you happen to have a drink, it's very unpredictable.
Right.
People respond completely differently all the time. And many people, not many, but some people have had bizarre experiences such as the sleepwalking or being operating in somewhat of a blackout. Do things that are very dangerous themselves and others.
The FDA has recently cut the dosage in half, the recommended dosage for men and women to address this. And so if you don't know this, please take a look at your Ambien bottle. It's 5 for women and 10 for men.
And maybe have a conversation with your doctor about
Yes.
alternatives, or if you can cut your dosage.
Right.
Gabe, the Colorado Department of Transportation has determined that if you get a DUI, whether it's Ambien or alcohol or drug related, it's going to cost you over $10,000 to get through that, not the least of which of that expense is going to be about $4,800 increase in insurance expense. Now, you're going to have to deal with somebody like me, you're going to deal with the district attorney, and you're going to deal with somebody like Robin down there on the end. And I think we're all really nice people, but we all going to be tough on you because it's going to cost you money to deal with us. It's going to cost you time out of your lives. And what you've got to understand is you may well lose that driver's license of yours for a considerable period of time. Think about it before you get in the car and drive with a drink under your belt or alcohol or drugs.
Couldn't have said it any better myself.
You know, the problem with consuming alcohol is that, as Sherry said, it numbs the inhibitions, so people are not in a position to make accurate judgments about most anything, least of all their own ability. They are the last person to decide whether they are competent to drive. So we have good, law-abiding citizens that make a mistake in judgment, and then they are seen as criminals or at least lawbreakers. And so we really have to look at the nuts and bolts of how this happens. And we have approached this, and with the district attorney's office, we have learned over the years that this is a much more effective way to eliminate this kind of behavior and this kind of danger on our roads. It's a highly successful approach, very innovative, and I think it also comes with a decent amount of respect and allows the client to have some ability to stay in the community, to remain employed, and to function. We don't want to remove good people from our community because they made a bad choice, a behavior choice, but we do want to make ourselves safe. And we get to have that level of safety here.
And that really is why we have all these laws on the books anyway, is to keep everyone else safe. Final thoughts, Sherry?
As an employer, you would not want your employee coming to work after a 1 or 2 martini lunch, because they're doing something that is takes a little more effort, takes thought, takes you being sharp. We want that same thought process to go into driving, because you have to be thoughtful, sharp, you have to be aware. And so just like we don't want you to go to work after a few, don't want you to get into a car after a few.
And let's face it, if I slur a word or say something wrong on the air, there's a lot fewer penalties, well, depending on what kind of slur it is, than there are if you're getting behind the wheel when you're intoxicated in one form or another by some kind of drug or alcohol. Thank you all again for being here. I appreciate it. I had a good time. Hopefully it was useful time for you as well.
Mention cell phones. That's another thing that I see a lot of with people having a drink or two, and they've got to make a telephone call or they've got to listen to music. If you have a drink and drive, pay attention to the driving and put the cell phone or any other activity away and pay attention to your driving.
Fair enough. Again, 9th Judicial District Attorney Sherry Caloia, Robin Starr from Addictive Behaviors Counseling, and of course, Dan Shipp, who we know very well, if for no other reason than for the voice. You do stand out. I can see why folks want to hang out with you at parties. I know you hate holding court and visiting with people.
One of the best accents around.
Yeah, there you go.
Yep.
Thank you again all very
Thank
much.
you.
I appreciate
Thank you,
it.
Gabe.
You've been listening to KMTS Connections, a public affairs program from KMTS News, heard weekdays around 12:30. It's another reason we are the most listened to radio station from Rifle to Aspen.